So Simeon Burke was convicted yesterday in the district court. He was charged with a public order offence. Just to put the offence in context, it's sort of an offence that you might see a young man going on a stag weekend in Carrick-on-Shannon or Kilkenny or someplace, and he's caught urinating in the street, and he's prosecuted by an ambitious young guard looking to making moves in the world. That's the sort of offence. It's a minor offence. It's a public order offence. In this particular case, the offence was to do with engaging in threatening, insulting and abusive words and behaviour on or about the Four Courts on March the 7th. And this was the Court of Appeal decision involving his brother Enoch Burke's case and Wilson's Hospital. There was a bit of a melee that day where this man, Simeon Burke, a law student at the King's Inns, he's a barrister, trainee barrister, was dragged out by the guards. He was arrested and he was prosecuted then with this public order offence, which, as I say, is a minor offence, but is an offence nevertheless and could lead to a criminal conviction. I have pointed out before the difficulties that having a criminal conviction can give rise to, from the point of view especially of one's career, from the point of view of a profession, from the point of view of travelling to a foreign country like the United States or Australia. The United States and Australia don't like admitting criminals or people with criminal convictions into their country, so getting a criminal conviction can cause difficulties, and especially for a young person who might at some stage want to travel out abroad. Anyway, the few weeks ago there, the process is Mr. Burke, Simeon Burke, would have been given the opportunity to either take a date or a plea. Did he want a plea or a date? A plea involves pleading guilty, and taking a date means that he's going to fight the prosecution and is going to contest it. He didn't make a plea at that stage. He took a date, so he was going to contest it. It was contested yesterday. At the time, I'm not sure how many Garda witnesses there were yesterday, but at the time when the evidence was being disclosed to him as part of the procedure leading up to the hearing, it was said that there would be 5 Garda witnesses. So you had a situation where this young man was going to go into court and swear one thing or give evidence about one thing or one version of events, and he'd be up against 5 Garda Síochána who would give presumably evidence contrary to what he was saying. In other words, they would give evidence to support the contention that he was basically guilty of this public order offence. On Sunday on my YouTube channel, I posted a comment, and I'm going to put it up on the screen there now. But as part of the comment that I posted, I said, but the way I would have, I said, there's an easy way to deal with this in my view, but the way I would have is pragmatic and does not allow an individual to climb up onto a cross and make a bold bid for martyrdom. So my way is unlikely to be followed, and it wasn't. Incidentally, any working solicitor who operates in the district court up and down the country dealing with minor criminal offences, which will be dealt with summarily in a busy district court, would probably give the accused person the same advice. It's not rocket science, but would lead to the best risk-free outcome, which might be reviewed in 5 or 10 years as a smart approach, but no self-immolation. That was my view, and what I was getting at was this, and I've already tweeted about this. If he pleaded guilty a few weeks ago and didn't take a date, if he pleaded guilty and threw himself at the mercy of the court, and he could have done it yesterday as well, quite frankly, before the hearing started. He could have pleaded guilty yesterday. He could have changed his plea. If he pleaded guilty, and if he apologised to the guards, and if he, in mitigation, explained to the judge that he's a young man of 22 or 23 years of age, that he got carried away in the passion of the moment that day on the 7th of March in the Court of Appeal, that he's a law student, that a criminal conviction would have serious consequences for him, And if he pleaded guilty and suggested to the judge that the best way or the most appropriate way to deal with this would be by way of a contribution to the court poor box, and for him to be given the Probation Act 1907. The significance of that is that he wouldn't have a criminal conviction. The money that he would be paying into the court poor box, €300 let's say, would be a contribution to the court's poor box, not a fine. There'd be no criminal conviction. The judge might well say that the facts have been found against him, but wouldn't go on to mark or record a criminal conviction, would given the benefit of the Probation Act, and he would be, he'd live to fight another day. In other words, he wouldn't have a criminal conviction. That is very, very significant in my view. That's a course of action that I believe he should have taken. The choice then, the other course of action was to fight 5 guards giving evidence on oath. And as I said the other day in a different video, you have 5 guards giving evidence on oath. You have Simeon Burke giving evidence. What is the judge going to do? He's probably going to side with the guards. Now, at the end of this hearing where Simeon Burke did indeed cross-examine the Garda witnesses and so on and so forth, they had given evidence that he was shouting and screaming largely unintelligible insults in regards to transgenderism, that Garda members should be ashamed of it, and there was a comment about going to Tala to deal with proper criminals. So Sergeant Griffin said Gardaí tried to reason with the accused, and the sergeant said he tried to calm the situation and ensure the arrest was done effectively. The sergeant said he pointed out to Mr. Burke Burke had his glasses in his hand and was squeezing them, and he feared they would break, but he was not listening to me. There was a physical struggle before he was put in a Garda van. Witnesses alleged that Burke gripped and grabbed benches in the courtroom, latched onto the door and put his feet against the wall as he was taken out. Mr. Burke himself was the sole witness for the defence. Court Garda Michael McGrath said the accused shouted and acted aggressively in the Court of Appeal, and the judges left the courtroom due to interruptions and objections by the Burke family. Garda Thomas Byrne said the accused was determined not to leave the courtroom, and there was high-pitched screaming. Arresting Garda Conor O'Dwyer said the accused kicked out and commented about transgenderism. He described his behaviour as appalling and rejected Burke's version that he was never told the reason for the arrest. Garda O'Dwyer told Judge Hughes it was explained to the accused when he was led to a Garda van which brought him to the Bridewell station. So State Solicitor Declan Keating submitted that it was the State's case that there was a melee in the courtroom first. In his evidence, Burke insisted he was not lawfully arrested. He claimed he was left in shock, his shirt was ripped, and he needed medical attention afterwards in custody. He told the court that there was freedom in Ireland and the country did not have to accept transgenderism. He admitted that he did not comply with Gardaí and pushed one officer, but claimed he had not been told to leave. He denied claims that he was shouting or screaming. After delivering the verdict, Judge Hughes reminded him that contesting the case meant the court could not give him the same credit as a defendant who pleaded guilty. And this is the point that I've made at the beginning of this video. If he had pleaded guilty at an early stage, he would have got a lot of credit for that, because it would have involved no prosecution or no need for 5 Gardaí to come along and give evidence in this hearing, no need for further procedural steps in between, and he would have been given the benefit of having pleaded guilty at an early stage. And when I say given the benefit, and that's what Judge Hughes has referred to, I suggest that given that he has no previous convictions, that he's a young man in a legal or training to be a barrister, that the likelihood is he would have been given the Probation Act and would have avoided a conviction. He had no criminal convictions, Mr. Burke said, and he asked the court to be spared the record outlining his accomplishments, including a President's Award, a law scholarship, work with international organisations helping disabled children. He also told the court he taught music to young people but could not say how much he earned. He said he was a responsible citizen, brought up to be a dutiful member of society. I beg this court to leave me without a conviction. I beg this court to leave me without a conviction. If he had pleaded guilty a few weeks ago, he wouldn't have had to beg the court to leave him without a conviction, because the likelihood is the court, as I say, probably would have given him the Probation Act. Judge Hughes noted the time he'd spent in custody, having refused to take up bail, and offered him the opportunity of an adjournment to engage with the probation service. This is very interesting. The judge offered him the opportunity of an adjournment to engage with the probation service. So possibly there was still the possibility of avoiding a conviction. At that stage, following a conference with family members, Burke demanded a strikeout and claimed prosecution witnesses had committed perjury. So here is a situation, an inflection point in the hearing, where the judge is offering him an adjournment to engage with the probation service. And perhaps if he engaged with the probation service positively, perhaps the probation report that would have followed would have led the judge to not impose a conviction. Might even have escaped with the Probation Act. But instead, following a conference with family members, Burke demanded a strikeout and claimed prosecution witnesses had committed perjury. Finalising the case, Judge Hughes remarked that law and order must be maintained in the courts of all places. He said the use of force was an aggravating factor, and he noted how the incident continued into the yard of the forecourts. He recorded a conviction, imposed the fine to be paid in 6 months, and set recognizance at €200 in case of an appeal. So Simeon Burke has been fined €300 in the district court, public order offence, and he has a conviction of a criminal offence. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.